Welcome to Drinks with Defenders. I'm Addie B-Plate.
And I'm Kayla Murphy. We're two law school friends turned criminal defense attorneys turned podcast hosts.
We're here in this space because we now work in separate offices and miss collaborating with each other.
We've been talking about creating a podcast for years where we talk about the complexities of the criminal justice system, the aspects of it that we grapple with, and the importance of what we do.
At the end of a long work week, we want to sit down, have a drink with each other, and talk about the rabbit holes of criminal defense, just like we always have. So let's get into it. Cheers!
Hi, guys.
Hey, good morning.
Hello.
Hey,
It's been so long.
I know. We're here. We made it.
Thank God. This morning has been a grind. I just finished a motion that I've been working on for I don't even know. I guess maybe 15 hours between the past couple of days, but it's freaking done. It feels good. I've been writing a lot of effing motions lately.
What was the motion for?
It was a motion to suppress statements and evidence and dismiss the case. You know, classic sloppy police work that we love and hate so much, right?
And as a topic of constant discussion on Drinks with Defenders.
Oh my God.
And for people like me, what's a motion?
It's basically like you are telling the court the facts of your case, what the law is, talking about other cases that are similar to your case and what the courts in those cases did, and asking the judge to do what you want, right? To do something. Addie, maybe you can explain it better.
I will summarize it. I think that just broadly motions are just you're asking the court to do something. So there's motions for all sorts of things. There's motions to dismiss, there's motions to suppress, there's motions for things like getting clothing for your clients who are incarcerated to wear court clothing to court so that they're not in their jail uniform in the courtroom, specifically, usually for trial.
Oh, wow.
And so there's motions for all sorts of stuff. It's just kind of lawyers' way of talking to the court, asking the court to do something. And usually, it's at every stage of the case after somebody's been sentenced, you can still do motions, like motions for extensions, all sorts of stuff. Motions, and Kayla, it's funny you're saying that. You're just firing off motions. I had a prosecutor once who I think got a little bit upset that I was filing so many motions on something. And I was just like, what do you think we do? That is literally our job. Anytime we want something done, we have to file a motion.
Or they could come to the table and wheel and deal and save you both a lot of work.
That would be also an alternative, but sometimes not a very feasible one, depending upon the situation. So
exactly. Have you found with certain prosecutors, you have to file a bunch of stuff because they don't want to negotiate with you or take your issues seriously?
Well, I think that is something that is hard in my practice, is that I always struggle with motions to suppress because in the community that I work in, motions to suppress signal that you're rejecting an offer. And so I do find it a little bit difficult because it's okay, it could strengthen your case if you have a really good motion to suppress and then you get evidence limited. But it also could just have different consequences on your case. But in some cases, file the motion and then eventually, I had a longstanding fight about a case and I filed motion and we had a hearing on a motion, and then the state ultimately ended up dismissing it a few weeks later. But sometimes I feel if you are really on top of your case, depending upon who you're working with, or I should say against, if you file a bunch of shit, maybe they start taking you a little bit more seriously.
That's the hope.
Depends. Yeah, It just depends.
Or it's if they just don't respond to you,
Yeah.
It's like a way to,
Here we go.
yeah, don't really have many other options.
Do I have your attention now? Yeah.
Love that.
So how many motions have you been doing, Kayla?
Oh my God. I had two due on the 21st. One was like, oh God, I don't know, maybe 12-ish pages. The other one,
Oh,
I think, was only like 6. But these take freaking forever. And maybe
yeah.
it's just like double checking the law takes forever, right? Shepherd, it's just
And also
so
feeling like
annoying.
your work product is good takes forever.
Exactly. Exactly. Yeah, it feels like it's making me smarter though, I know that it's good for me, like running or
Hey.
something, which I don't do. So this like mental
You're
running.
making up for it. You're making it up
Yeah,
for it with your
exactly.
pen.
Oh,
And and
yeah,
just so I understand the process, like first you would make a request to the prosecutor, and if they deny that request, you would then make a motion to the judge or court, or
It
you can just make
depends.
a motion, period.
It depends on what it is. Like certain stuff you don't necessarily have to go through the prosecutor to ask for. If you want them to agree, like stipulate, you might reach out to them because you still have to get a court order for certain things.
Hmm.
So certain things like you need to go through the court process, which is why you ask for, that's why you file a motion and then usually a proposed order for the judge to sign so that what you're requesting gets done in your case. Certain stuff the prosecutor can do without having to go through the court process. So it depends on what you're trying to accomplish that I think you determine whether or not you go through talking to the prosecutor. But to answer your question, you can file motions without ever having to ask the prosecutor for their green light on it. You can just be like, hey, I'm filing this, which I do all the time. I'm just like,
totally.
okay, there's certain stuff I'm not going to waste my breath in talking to you about. So,
Okay.
yeah.
Exactly. Exactly. I
Yeah.
mean,
Like,
it's specifically in the context of like search and seizure issues or, situations where the officers didn't Mirandize somebody when they were subject to custodial interrogation. Sometimes you maybe bring those issues to the prosecutor's attention and say, hey, we have all of these potential motion issues. Why don't, let's play ball. What do you think about dismissing this charge if my client pleads to this charge? Or, amending it to a lesser charge or joining me, in an agreed sentencing recommendation for no jail time or something. And then maybe the prosecutor says no, or they don't respond to you. And then go back to your client and you're like, okay, well, whatever, they're not playing ball. So do you want to just like ask the court to do this basically and just litigate it? So I think it's kind of a strategy thing. I think it's so interesting how people's different practice styles, I guess, have such a big impact on their workload.
oh, yeah. Oh,
Isn't that
yeah.
interesting?
I have an attorney in my office who is just, I don't know how this person functions because he's just a machine and he like cranks out
Mhm.
motions and he just files shit like all the time. And I'm like, how are you just like, do you just stay up at all hours of the night writing? Because when do you get this done? Because we're litigating every single day and you have how many cases and you're just filing shit left and right. And it is so impressive, but I cannot imagine having like that person has to work twice as much as me and I work a lot.
Yeah, you do.
So I have no idea how certain people do it. But it's super true. Like if people are just cranking out stuff, I don't know how they do it.
Hmm.
Genuinely. Good for them.
Or like going to trial all the time. It's so
Yeah.
interesting too, like how big of I like an attorney's attitude. I feel like particularly a criminal defense attorney's attitude has such a big impact on the direction that your clients kind of decide to go.
Oh
Like,
yeah.
of course, everything's ultimately their decision, right? And you're like just there to give them the education. But I don't know how to explain it, but it's like your vibe, I guess, just kind of goes like one way or another. Like for me, I feel like more often than not, I kind of have like the fuck 'em, make 'em prove it vibe. You know what I mean? And my clients like kind of like are into that and like, yeah, like let's like, fuck 'em, like make 'em prove it. Let's go to trial. But it's like I think other attorneys or like, me like when I wasn't as comfortable litigating stuff, it's like, I don't know. They could always do this, or, the judge could always, you know what I mean? It's like you tell them the same information, but it's like, I think that they can just sense your, I don't know, maybe confidence or something. What do you think,
Mm.
Addie?
I'm going to give a shout out to a previous episode of ours where we had my colleague Justin Ackerman on this podcast, because I think he spoke about this really well, and I think that his brain in terms of how he approaches cases, because he goes to trial a lot, and I think that his clients really pick up on what you said, like an attorney's confidence and an attorney's like, people have attorneys for a reason. We review cases and we just go to our clients and are like, hey, we did all this stuff in your case. What do you want to do about it? And I think the workload and presentation that you take to your clients and the way you convey that information to them, I think really has an effect on what they intend to do or how they feel about their case, because obviously most of them aren't lawyers. So they are trusting and I think there's some interpersonal, cues that are built into that communication that people pick up on. And they're like, oh, okay, what do you think about this? What do you think about that? And I think if an attorney comes and is like, I'm confident we're going to do this, here's my attitude in cases, more often than not, I think clients pick up on that and they trust that. Certainly you have cases where you fight with your clients the entire time.
Yeah, for
but
sure.
and you're just like, hey, I don't think you should do this, but like it's your choice at the end of the day. Or like, hey, I really think we should do this, and they don't want to. And yeah, it's that relationship is very interesting. I would say.
If anyone wants to check
Oh
that
my
out, that's
God.
episode 5 with Justin Ackerman.
There you go.
Thank you, Clark. Yeah, I loved that episode.
So,
So
I mean,
today,
yeah, okay.
okay.
Happy 4th,
So,
guys. Just so everyone knows, we're recording this on July 4th. No days off for drinks with
damn,
offenders.
Ever,
that's fair.
ever. Oh
Mm.
man, I'm just gonna say, I'm just gonna speak to the elephant in the room. I think I'm good at that.
Oh my God, Addie, I just have to say real quick, you just reminded me of our freaking law school having those like actual elephant representations
Dude,
in the different rooms. Clark, it was like this, I don't even know.
Was there someone in a elephant suit?
no. It was a silent protest by the students regarding something that was happening at our law school. That students thought was an issue. So they inflated a giant elephant, like a life size, almost looking elephant, inflatable, and left it in our law library as like a protest to there being an elephant in the room at the law school that nobody wanted to address.
That's
I didn't know
genius.
that it was the students who
Yeah.
did that. I thought it was the
That's what I heard.
administration.
That's what
That
I
makes me
heard.
like it more.
Or maybe it was the administration. It was a silent protest about there being an elephant in the room with like an issue at our school. Which I thought was very interesting and kind of inspiring. Like once you understood what it was about, because there was a problem with I think it was in response to a faculty issue. If you know, you know. If you lived that experience, we were there.
So what's your elephant in the room?
I think that something that is very difficult, and it's been this way for a while, is that, and maybe I've mentioned it before, but being American and engaging in politics or thinking about political issues, just in terms of modern life, like America is built upon, I think, a spirit of rebellion. I think that there's that just in our history and in our culture. But being a lawyer and somebody who was going to law school, I think in modern history, and I'm going to chunk that up to the last 10 years, um, is, I think, very disheartening, because there's just been a lot of things that I think have been really hard for people who want to study law, want to practice law. And then I think a lot of the decisions that have happened and changes in the law where it just kind of feels like, what's the point? Like, what are we doing? What do we believe in anymore? And I say this to the people that came out of law school and there was like the job market crash where there really wasn't a lot of opportunities for lawyers. And then we go, our era of law school where we were in law school during, the Trump administration. We were in law school and I took longer in law school. So I was there through the, appointments of Justice Kavanaugh and Justice Barrett and all of these two Trump impeachment, like just crazy shit happening in the court. and at our highest court, and then courts across the country. I was studying for the bar exam the year of the Dobbs decision, which was, the case that overturned abortion, or Roe v. Wade. And all of the things that have happened in the last 10 years, I think, have just been really hard as somebody who's a lawyer, because you're just like, who do we fight? What, like, I'm so angry. All of these changes are happening. What is the law? The law is constantly changing. And some of us expect that, but it's been really frustrating and like scary. And I think that we were talking about doing this episode on the 4th of July because I think that the America I'm proud of has a spirit of like, and there's not a lot of things that I'm super pleased with or proud of in our history. But the things that I'm proud of in our history are acts of rebellion, acts of like trying to establish a better system of government and things that aim at that goal. And I just feel like with the most recent decisions from the Supreme
If I
Court, some of
could
it,
just say real quick,
yeah,
I love that, and I feel like what you do and the profession you've dedicated your career to up into this point, like it itself an act of rebellion against an
yeah.
unjust system, you know?
I mean, same to you. And so like, I'm sitting at looking at the world and understanding the world and the rule of law from the perspective of I practice criminal defense in the most incarcerated community in the democratic world. Idaho leads the nation. Idaho leads countries in the amount of most incarcerated people. Like Idaho as an
Wow.
institution is the most incarcerated community in the democratic world. We also have the highest amount of incarcerated women per capita. Like, so I'm taking all
Wait,
of this in.
Idaho's the number one state for incarcerating people?
Yes, and we also are higher than the national average. As you know, the US leads the democratic world in the most amount of incarcerated people. Idaho's higher than the national average, which means Idaho, as its own territory, leads the world in the most amount of incarcerated people. That is nuts.
Holy smokes.
I had no idea.
Yeah. So back to the most recent drops of just, what's happening with our courts. Like, it's hard to not have a visceral reaction to that as somebody that is trying to shape the law or fight the law for things that I think are not only in the best interest of my clients, but the way that the law works. Like some of the fights that we do for our clients don't benefit our client. Sometimes, like the law, if you're fighting something for your client, you're trying to change the law, the ripple effect is on usually future cases, right? We know that. And I'm scared for the decisions that we're seeing in terms of the effects that come in the future. And that's, I think, the thing that's felt very real and very difficult to digest.
Yeah.
And in that spirit, Addie and I each just picked a case or a decision from the Supreme Court that came down recently, just to like briefly chat about. And Addie, do you want to go first?
Sure. Oh God. Drum roll, please. I'm here to talk about Trump because aren't we? It's just
Oh man.
yeah. So I'm just gonna say something that's been very, I think, educational for me when I was looking into the presidential immunity case was I actually took the time to listen to some of the audio from the hearings, from the Supreme Court hearings. As most people know, cameras aren't allowed in the Supreme Court, but there is audio. I found it on PBS where the justices are questioning the Trump lawyers. And I did that after I had read parts and pieces of the decision. I'll get into the decision in a minute, but just in terms of how I digested this media myself, of course, as a normal person, I learned about the Trump immunity decision through social media. I went and looked at the decision. I have it pulled up. I believe it's 119 pages. I think that sounds right. And most of it incredibly disappointing. So I was kind of reading and I was like, okay, it seemed from just like a first glance, I'm going to touch on Justice Sotomayor's opinion, because I think that's kind of, I'll get into what the ruling was, but I think her opinion was really interesting for a few reasons. But I went to PBS and was trying to listen to some of the audio from the hearings because it seems like the three dissenting justices, Sotomayor, Kagan, and Justice Jackson, um, they all had kind of different takes on why their dissent was the way that it was. And so I listened to the clip of Justice Kagan's questioning to Trump's attorneys. Um, I thought that was really interesting. I also listened to Justice Jackson, who I just am going to say I'm so impressed with Justice Jackson's questionings. She's new to the bench. I feel like she just kind of really went for it with some of her questioning. And appellate arguments also really interesting because just the justices would just ask questions and questions and wouldn't let Trump's lawyers speak, and they'd flip it and it'd be a different hypothetical. And so it was really interesting. I think just I hadn't really taken the time to listen to any SCOTUS argument before. I would highly recommend people who care about what's happening in our Supreme Court to take the time to understand how that operates, and think about, I don't know, just diving into that. It was a really good learning experience for me. So kind of breaking it down, obviously, I didn't have time to read the full decision because I am a 9 to 5 public defender, but I did take the time to kind of read some of the clips about what's important from the case and just kind of the heart of it. So, as most people know, the case really, the Trump versus United States case, it came down to a 6-3 vote that was largely split along ideological lines. The three justices who were nominated by Trump sided with Trump. I think that that is always just going to be kind of a mar in political and legal history. Disappointing. The ruling, among several things, determined that the former president has immunity from criminal prosecution for any official act that he took while in office. The ruling has some other subtle nuances, stating presidents can still be found criminally liable for unofficial acts. I think Justice Jackson's and to some extent Justice Kagan, the audio that I listened to was them trying to really narrow down the scope of official acts, because I think that's a huge concern that I think is left a little bit open from the opinion. The court ruled notably that the acts for which a president is immune from criminal charges cannot be used as evidence during trial on other matters as well, which I think is a huge evidentiary issue, considering that Trump has other cases that are going to be litigated, not just the case that was before the court, but which was largely tied to the insurrection. But there's, other federal prosecution cases that could still arise from some of Trump's actions. And so the scope of what gets to come in evidence, I think, is a big concern from this opinion. I think that's scary for what it means going forward. Diving more into it, in case you need a little background, the case arose out of a special counsel indictment against the former president for his activities in relation to the January 6th insurrection. The defense was essentially Trump saying that he's immune from anything he did as a president, which then kind of goes to the question as to what extent a president could be immune from the criminal process for acts that were taken while in the capacity as a president. This had never been presented before to the court before. I think that if you study the law or you're just really interested in politics, perhaps some of this case flags Nixon concerns, because in the 1980s, there were some other decisions related to civil damages that a president could be liable for. So I think that this is more interesting because we're getting into criminal behavior and criminal conduct. Essentially, a big part of the question came to whether, I think one of the issues in the case is how to compare criminal immunity to civil immunity. Should it be more broad or more narrow? And the court largely concluded that criminal immunity is somewhat more narrow than civil immunity, that it had recognized before. Yeah, I'm going to turn to some of the things that I found interesting in the case. I am just going to go on my soapbox of saying that I think Justice Sotomayor is such a good legal writer. I've heard when I was an undergrad that dissenting opinions, while they're not, you know, technically the law, there's some really good meat in dissenting opinions for when you want to change the law going forward. And I think some of the argument in Justice Sotomayor's dissents, not only from this case, but, I think she wrote, maybe it was the Dobbs opinion, but one of her other opinions in the past, she talked about how the Supreme Court had buried its head in the sand. And she's just such a fabulous writer. I read her memoir. It's not just her, writing from the bench that may be also tied to staff attorneys helping her write those opinions. She's just a fabulous storyteller. And she does really good alliteration. I feel like reading good opinions in law school made law school a little bit more bearable. And she's just, I literally eat up everything she writes. I think she's just fabulous. But something that I really liked in her opinion was not only just some of the comments that she made and how convincing in terms of how she structures her arguments that she does, but her citations I think are wildly underrated. Justice Sotomayor, in her dissent, cites to the Dobbs opinion, which I just found so interesting. So there were two pieces of her dissent where I just thought she was scathing. But she wrote this sentence and she cites to, I think, the gun case and then also the Dobbs case. But she says before that, the majority ignores this reliance. It seems history matters to this court only when it is convenient. And then she cites to Dobbs. And I think it's just kind of a jab at the court continually overturning precedent lately. And the amount of precedent that's been overturned with, this case with Dobbs, with I think one of the cases you're going to get into, Kayla, she does it very subtly, but she throws the language of the majority from Dobbs back in the majority spaces. It's just really well done. She also, I enjoyed some of her argument, but she also cited Dobbs when she said the official act's immunity has no firm grounding in constitutional text, history, or precedent. She cites the Dobbs again. I really enjoyed her dissenting opinion. The majority I found really difficult to read. I'll talk about the Dobbs decision in a second because I went back to it when I was reading the decision and Justice Sotomayor's opinion. But I found this part also very interesting, where she says the majority calls for a careful assessment of the scope of presidential power under the Constitution. For the majority, that careful assessment does not involve the Constitution's text. I would start there. So she's saying that, they're making a constitutional argument, but they don't care about the Constitution at all. And that's like, in some, I think, my reading of the case. I really struggled. I read the majority opinion. I found it on a news site and then it linked to reading the whole opinion. I would encourage everyone to just kind of take a glance at it. I tried finding it in Westlaw, which is kind of like Google for lawyers. I don't think I couldn't find it on there yet, but I went back and was reading the excerpts from Dobbs and the sections that she cited to. And I found it so infuriating when I was scrolling back through the Dobbs case, all of the red flags from all of the things that were like, cases that it had overturned. And that made me so angry. And for those of you who don't know what reading an opinion looks like, when you go into, like I said, Google for lawyers, when you go into a case and you're doing, reading the case, every opinion in a case cites to other cases because people, like Kayla said, lawyers have to argue the law in support of their argument. At least they should. And so they cite, and then in Westlaw, like it'll have a yellow flag or it'll have like, a red flag if it's something that's been overturned. And if you go through Dobbs and you just see the sheer amount of red on that page, this I think is going to be the same thing. Or maybe not, because it, like I said, hasn't really been discussed before the court before. But yeah, it was a really interesting case. It just felt like kind of a 1-2 punch. We came off of a really difficult presidential debate. I think the Democratic Party more generally is kind of needing to shift in terms of thinking about strategy for the upcoming election. I wouldn't be surprised if the Democratic Party decides that they want a different candidate. I don't know who that candidate would be, but you come from that straight off the heels of that to a really political opinion that gives Trump more leverage to justifying some of the things that I think, had the decision gone the other way, the American public would have viewed as indefensible.
Absolutely.
I think it has not only just huge legal ramifications, but very big political ramifications, absolutely, in terms of the upcoming election.
Did the court's decision surprise you, or did you expect that they would rule this way?
I'm not surprised. And I think that that's the thing that is so frustrating. And I think that that's something that is a very personal anger, because I think some of the job as a criminal defense attorney is to fight with judges every single day. And you're saying, hey, maybe it's on appeal. This judge was wrong, and here's why. And I need you to listen to me. This judge was wrong. Or, hey, the state's wrong, and I need you to listen to me, and here's why. And oftentimes I feel like I go to a judge and I know that they're going to not agree with my argument, but I always struggle with how they're going to justify not agreeing with my argument.
Totally. I know exactly what you mean.
That feeling. And it's just like, of course, the majority was going to find a way to rationalize that conclusion.
Well, because at the end of the day, man, we're all just people, right? And people can justify anything to themselves,
Yeah.
in my opinion.
And this gets back to the nuances where you can still be a defense attorney because it's a very defense friendly case, right? If Donald Trump's your client, it's a defense friendly opinion. And of course, a former president or a president has the best lawyers that they could think of in theory. So it's that tension we've talked about on here before, but it's very frustrating, I think, just to the average American for what that means for the rule of law. And of course, on the 4th of July, I think it really points to the spirit of what this country should be about, being anti-monarchy and anti a king. And in this case, I feel like it really signals that, hey, we're back there where, there could be essentially a monarch.
Yeah.
Is how it feels.
And speaking of a monarch and a police state, the
Please.
case that I chose to chat about was the case coming out of Grants Pass, Oregon.
Oh, no.
So essentially, Grants Pass is a small town in, I believe it's Southern Oregon. They have a population of 38,000 people. And the city had an ordinance which was a camping ordinance, right? It banned people from camping in public places like sidewalks, public parks. And the ordinance mandated that basically initially it was punishable with a fine, but then it escalated to be punishable by up to 30 days of jail after a certain number of convictions. And the issue was that there weren't any public shelters available. Basically, my understanding is that the shelter that was available had some requirements, right? Like
most of them do.
Right.
Most shelters for unhoused folks have, substance testing or things like that. And if you have, I know in some instances, if you have like a prior qualifying criminal record, usually I think it's like domestic charges or things like that, you can't be at the shelter.
Or God forbid you have like a dog, right?
Yeah.
Or like, yeah, something like that. Or maybe you don't feel safe there. Maybe you're particularly vulnerable. Maybe like, I don't know. There's a lot of reasons why people might not feel comfortable staying at a particular shelter or not be eligible to stay at a particular shelter. So basically, a group of homeless residents challenged the constitutionality of this city ordinance, saying that it constituted cruel and unusual punishment under the Eighth Amendment.
Because essentially you're potentially allowing for jail time for somebody who just has an unhoused status. I think that's the argument, like penalizing people with potential jail time for being unhoused amounts to cruel and unusual punishment, right?
And we are on the same wavelength because I have a little excerpt here, which I'm going to read. So, grants pass public camping ordinances. This is from the opinion. Do not criminalize status. The public camping law prohibits actions undertaken by any person, regardless of status. It makes no difference whether the charged defendant is currently a person experiencing homelessness, a backpacker on vacation, or a student who abandons his dorm room to camp out and protest on the lawn of a municipal building. Because the public camping laws in this case do not criminalize status, Robinson is not implicated. Okay. Um,
Oh, there's a lot
Yikes.
to unpack there.
Yikes.
What is Robinson?
It was, go ahead, Addie.
Is it the defendant?
Oh, okay. Okay.
No, this was citing a prior case. This is just an
Okay.
excerpt from the case that talks about their reasoning behind why it's not criminalizing homeless people, right? Because they're homeless. They're saying this applies to everybody, even if, whatever, a theoretical protester.
Which I think is such an also odd commentary on the state
Right.
of like active protests in the United States by college students. Like it's an extra slap in the face for protesting that's currently, I think, at the heart of political discourse in the US at the moment as well. Like a subtle comment, I think, on college students who are currently protesting other things across our country.
It's interesting too, thinking about their rationale for why it's not considered cruel and unusual punishment. Here's another little excerpt here. So the court cannot say that the punishments grants pass imposes here qualify as cruel and unusual. The city imposes only limited fines for first-time offenders, an order temporarily barring an individual from camping in a public park for repeat offenders, and a maximum sentence of 30 days in jail for those who later violate an order. Such punishments do not qualify as cruel because they are not designed to, quote, supersede terror, pain, or disgrace. So that's what they're considering cruel and unusual, is if it's designed to basically inspire terror, pain, or disgrace. They're saying it's not unusual because similarly limited fines and jail terms have been and remain among the, quote, usual models of punishing criminal offenses throughout the country.
Oh.
So really weird
And that was by SCOTUS?
rationale.
Yeah.
That's what that's from, yeah.
I think that it's odd too, because it's like, you're not, okay. I think the two things that are hard for me are number one, them saying it's not a status thing, but the amount of the people that in actuality are going to be punished for this are unhoused people. Number one. Number two, that it's not designed to terrorize people when you're literally just going to be having police interactions with people who don't have shelter. And then by that same nature, I think it has this effect where it'll cause people to move. They'll be pushed out of the community so that they don't get subsequent
concentrated in another community that doesn't have that kind of ordinance, which just exacerbates, certain problems within that community and like unfortunately may push them to pass their own kind of laws like this, right? Yeah, it's ridiculous. It's fucked up. It's very frustrating. There are certain offenses here in my community, the city of Wenatchee, that specifically seem to be enforced against homeless people.
Yeah.
Like there is a oh gosh, what is it? Pedestrian interference with whatever the fuck. Like if people are on the sidewalk with their stuff, right? They're interfering with pedestrian traffic, and it's a form of disorderly conduct, which is theoretically punishable by a maximum sentence of up to 90 days in jail and a $1,000 fine. And I've never seen it be used against somebody who's not without a home. I actually saw somebody be charged with interference with vehicular traffic as opposed to pedestrian interference because they were jaywalking, which is like, tell me that you would like, anyway, it was just
Man, that's just
gross.
like it's like they just put one cop out there and they're like, watch for this one guy. Just tell us anything he does it to mess up. That way we can just take him off the streets. That's what that feels like.
Well, and also the collateral consequences of that are big, um, in ways that I don't think the average person probably understands. Because I'm assuming that if it then increases in penalties and you remain unhoused and live in this community, eventually you get hooked with a misdemeanor charge, which could prohibit some employment opportunities, which then
Mhm.
further exacerbate the issues of poverty. And then
Maybe
also,
any federal benefits that you could have been eligible for that could have like gotten you off
Yeah.
the streets.
right. And if you, depending on, I don't know what it is in Oregon, but if you're in custody for a certain amount of time, things like Medicaid become
Hmm.
inactive, at least in Idaho, which a lot of people don't realize as well. And then also, maybe if you are then getting cited for, or getting, at some point, it becomes an arrestable offense, right?
Right.
And say you're getting arrested for being unhoused, and then you commit other violations while you're being arrested, such you start resisting arrest or something, all of a sudden it spirals into a very
You have
different
drugs
issue.
in your pocket.
Yeah, it
Yeah.
spirals into a very different issue. And that's a huge concern.
Does your town, or you, wait, you're living in Spokane right now. Does
Yes.
Spokane have these kinds of city ordinances?
So Spokane is, admittedly, since I practice in Idaho, I'm not as clear on some of the code sections for Washington and what's going on with city code stuff or statutes in Washington than city code stuff. I need to be better about that. So I don't know.
No. Where, I'm
But I,
sorry, you don't practice
there you
there,
go.
wherever you practice.
I was just, yeah. So I was going to say with my county, there's some stuff that I think is specifically designed for unhoused people. I will give someone in my office, and I'm not going to go into more detail than just this character in my office. We were in court once, and I was watching an attorney on the record basically say to the court that this is not how we should treat unhoused people in our community, and and that it was cruel, essentially. And I was a baby lawyer when I watched that, because I think the facts of the case stemmed around this person being like asleep on a bench or something like that, and some other stuff. And I was really proud of that lawyer that day because I was like, yeah, like, and I was thinking about it when I was getting ready before we hopped on the podcast. The other thing I'm very concerned about with this case and how it ties towards kind of everything is that class conflict in the United States is just becoming a much bigger deal. And
Yeah.
like the war on unhoused people is just magnifying the class divide and criminalizing unhoused people
I think the
further.
wealth disparity is like worse now than it was during the Great Depression.
Oh, it's
At least
huge.
TikTok told me that. I guess I can't confirm.
And then also like criminalizing unhoused people just further, like it just it makes poverty worse.
Yeah.
And it's just, I'm very scared because it's like, have we not watched other like societies go through big class conflict and not seen how that played out for them?
Yikes. I mean, totally, totally. I'm thinking about like all of the commentary when that submarine full of
Oh yeah.
millionaires,
Yep.
exploded. I mean, it's just, you can feel it. You can almost feel the tension. You see it in our discourse and stuff, right? And
Yeah.
it's certainly not like going to get better
No.
anytime soon. And you're right, these decisions just exacerbate the problem and further disenfranchise people. I mean, limiting women's rights to, be able to exercise decisions over their own body and obtain reproductive health, like that limits their ability to be free in the world, and disenfranchising people with like criminal records just for existing and not having a place to live disenfranchises them further.
Yeah.
Yeah.
I know this is all depressing. Do we still have more decisions we're waiting for from the court?
To be honest, I think I'm in like SCOTUS coma where I don't really know what's like coming down the pike
Yeah.
right now. I don't know what their calendaring is. I need to check. Um, I so I don't know.
The ones I was like really anxious about came down, so I like stopped paying attention.
Yeah.
But yeah, I unfortunately am confident that we will have more fucked up decisions to talk about.
I also just think that it's like I've also tried to do a better job of tracking certain stuff with like the state court system too, because that has such a huge effect on my job. And I just feel like overwhelmed by court decisions constantly. And I'm just like, oh, okay, like that's an L. Okay, that's an L. Like
Mm.
at some
Right, they're all
point,
L's.
at some point, like
So
we
true,
need to
man.
win. And yeah, it's oh, but
We can only
on a
control what we can control, and like, yeah, our jobs are acts of rebellion against this fucked up police state. So
it's true.
at
And
least we can take some comfort in that.
and at least we live in a country where people have a right to an attorney. And
And to express our opinions. We can have this
yeah.
podcast and talk about how fucked up this shit is, at least for now. Oh
Oh no.
no.
Well, I will say like a couple things here. We have some exciting podcast news coming down the line soon for everyone to keep an eye out for. More importantly, like every week when we get into our text thread, just to let our audience in on this aspect, like as heavy as this podcast can be with the topics that we talk about behind scenes, one, I'm always blown away by how positive you guys are in our group and how encouraging you are to me and to each other. And I think the one thing that I am constantly blown away by is one, how smart you guys are and how
Oh,
you guys are just like pouring over all this information. Like I tried to look up a law the other night and I was like going through it and I was like trying to understand how everything was like bullet pointed in A's, B, C, and then 3A. And I was just like,
what the fuck is this?
yes. And I was like,
Gross.
this is what they do every day, you know?
Yeah.
And then you're writing motions and all this other stuff. You guys are doing incredible work. And
Oh,
then on top of it, with how nice you guys are as individuals, I think just shows me how real you guys are as humans and you see the realities at hand and you're willing to deal with them makes me super hopeful. And I've said that like a million times before in our chats and on the podcast, but it's like, I
thanks.
don't want to lose sight of that. And I don't want you guys to lose sight of that, that like you're doing great work. And someone like me who's just like living my life and not knowing near as much about the law as you guys do, like it makes me grateful for what you guys do. So thank you.
I mean, thank you.
Thank you, Clark. We love you. And it's such a big part of being a lawyer is feeling like you're never doing enough and you're dumb. And so, yeah, it's really nice to hear that.
Yeah,
I
I could
think
never do it.
You could do anything. Anybody could. It's just a matter of what you're willing to suffer for. You know my spiel.
Yeah.
I think the thing for me too, like, thank you. I echo what Kayla said. And yes, big brag, like Kayla's done some exciting things that will be shared with the podcast soon. But I think the thing too, like in light of sometimes I think we bring really serious conversation to this space. And I think the reason is because I'm just not going to sugarcoat it. Parts of this job are really serious.
Yeah.
And I take that responsibility very seriously. And I come on here and I'm a little bit more, I think, no filter and less polished than I am as a professional. And I appreciate that. And I think that's part of why we have this podcast. But this job is really serious. The consequences of changes in the law are really serious, and the ripple effects they can have for people that I interact with every single day are really serious. And that doesn't mean that I don't have a really great attitude about what I do, because obviously there's a reason why I do what I do. And I think that Kayla, you're the same. But the thing that's so great, not only sharing like what I'm passionate about and like how excited I am about like little victories in this job, is also like I'm so inspired to do this work because I know that it matters. And I'm also so excited to like have the opportunity to really advocate for things that I think are important. And yeah, I think that that's the hard part about being a defense lawyer, is it can make you a little bit like you can get really down on hope with certain stuff, but like that little piece of hope is why you go and throw down in the courtroom, and write
Amen,
motions for
sister.
15 hours straight, right? Like there's a
I'm a
reason why.
psychopath. I'm
Yeah.
just
And it's,
principled and mad. And I honestly, you know me, and nothing like gets me more motivated than just being like mad.
oh
So
Yeah.
yeah. The anger is like half of why you do the job that you do.
it
But
literally is, but it works for
it's
me. So
also just like that little beacon of hope. I always feel very like I cling to that. And it's, I get mad, but I think when the anger kind of subsides, it's like I'm really hopeful about certain stuff with lawyers, and people I know change the law every single day, and
Mhm.
that's fucking inspiring. So
hell yeah.
yeah.
Well, on that note, till next time, cheers.
Cheers.
Cheers.